U.S. District Judge Tanya S. Chutkan on Wednesday rejected Donald Trump's request to recuse himself from the federal election obstruction case, saying the former president's lawyers interpreted two statements he made at sentencing in an overly sensitive, cynical and questionable manner. January 6, 2021. Capitol attacked defendants to accuse him of bias. In his 20-page opinion, Chutkan wrote that a reasonable person would understand that in making statements challenged herein, the court was not issuing vague statements about potential culpability of third parties in a hypothetical future case or Trump, as his lawyers have argued. The judge continued instead, it was his duty to expressly consider the defendants' arguments that their sentences should be reduced because others they believed were connected to the events of January 6 had not been prosecuted. The appointment of a new judge is appropriate, considering all the circumstances, and there is no adequate alternative. He will decide whether to reject it or not, said Stephen Gillers, a legal ethics expert at NYU School of Law. The appellate court will stay the unless it finds that it was an abuse of discretion, which means that it will be affirmed even if an opposing would also be reasonable. Gillers said, Trump could not appeal his decision until the trial was over. Can immediately apply for review through a writ of mandamus. But that path is too narrow and unlikely to succeed. Trump's lawyers, who asked for Chutkan to recuse himself earlier this month, said veteran jurist appeared to be biased about former president's guilt, citing comments he made while sentencing two defendants charged in Jan. 6, 2021. Attack on U.S. Capitol. In October, Chutkan implicated Trump when he told a defendant that he and others at the Capitol were there loyally, not the Constitution, but to one man, adding, that's blind loyalty one man. By the way, it remains free until today. Trump's lawyer, John F. Lauro, wrote in his defense filing that the meaning of Chutkan's statement was inevitable. That President Trump is free but should not be free. But prosecutors said Trump's defense cherry-picked two of Chutkan's statements out of context and misapplied the law by claiming the judge was biased against him, far from offering clear evidence of bias. Said Chutkan's statements an appropriate response to the two defendants' claims that they deserved leniency because were inspired by or less culpable than others who not held accountable. The court's statements regarding this sentencing mitigation claim were factually accurate, responsive to arguments presented to the court, and established that there was no improper bias or prejudice in instant case, wrote senior special counsel Molly Gaston and Thomas Wyndham. The U.S. Supreme Court unanimously ruled in 1994 that opinions formed through court proceedings would require a judge to recuse himself from a case only if those opinions exhibit Professor